Damages. Definition of damages. It is the pecuniary compensation, recompense, or satisfaction for an injury sustained, or as otherwise expressed. The pecuniary consequences which the law imposes for the breach of some duty or violation of some rights. Award must be monetary. In actions for damages, courts should award an amount to the winning party and not its equivalent in property. Damnum absque injuria. Damages will not be awarded in the absence of injury. There is a material distinction between damages and injury. Injury is the legal invasion of a legal right. Damage is the loss, hurt, or harm which results from the injury, and damages are the recompense or compensation awarded for the damage suffered. Thus, there can be damage without injury in those instances in which the loss or harm was not the result of a violation of a legal duty. In such cases, the consequences must be borne by the injured person alone. The law affords no remedy for damages resulting from an act which does not amount to a legal injury or wrong. These situations are often called damnum absque injuria. Lifted from 1955 bar. Under the principle of damnum absque injuria, the legitimate exercise of a person's right, even if it causes loss to another, does not automatically result in an actionable injury. Examples: when there is no easement of right of way, one who encloses his land with a fence, although the neighbors will be inconvenienced, is not liable for damages. The owner is just exercising his right to enclose his property. The defendant cannot claim damages against the plaintiff even if the case filed by the plaintiff was dismissed for lack of merit, if the plaintiff was in good faith in filing the case. The ordinary inconvenience of litigating that the defendant suffered is not actionable. What are the kinds of damages? Damages can be 1. Actual or compensatory, moral, nominal, temperate or moderate, liquidated or exemplary, or corrective. Pecuniary loss. Proof of pecuniary loss is necessary to successfully recover actual damages from the defendant. Proof of pecuniary loss is not necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. The assessment of such damages, except liquidated ones, is left to the discretion of the court according to the circumstances of each case. Actual or compensatory damages. Article 2199 of the new Civil Code provides that, except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. Such compensation is referred to as actual or compensatory damages. What are the two kinds of actual damages? Daño emergente. It is the loss of what a person already possesses. This includes actual loss or money or loss or damage to property or even injury to the plaintiff's business standing or commercial credit. Second is lucro cessante. It is loss of a benefit that the plaintiff failed to receive. These include lost income or loss of earning capacity. When can compensatory damages for loss of capacity to earn recoverable? Under Article 2206 of the Civil Code, the heirs of the victim are entitled to indemnity for loss of earning capacity. Compensation of this nature is awarded not for loss of earnings, but for loss of capacity to earn. The indemnification for loss of earning capacity partakes of the nature of actual damages, which must be duly proven by competent proof and the best obtainable evidence thereof. Thus, as a rule, documentary evidence should be presented to substantiate the claim for damages for loss of earning capacity. By way of exception, damages for loss of earning capacity may be awarded despite the absence of documentary evidence when 1. The deceased is self-employed and earning less than the minimum wage under current labor laws, in which case judicial notice may be taken of the fact that in the deceased's line of work, no documentary evidence is available. Or 2. The deceased is employed as a daily wage worker earning less than the minimum wage under the current labor laws. Jose Angeles, GR 187899, October 23, 2013. People v. Villar, GR 202708, April 13, 2015. Extent and measure of damages. Crimes and quasi-delicts. The defendant shall be liable for all damages which are the natural and probable consequences of the act or omission complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. How about the death due to crime? What is the amount of damages? When death occurs due to a crime, the following damages may be awarded. 1. Civil indemnity, ex delicto, for the death of the victim. 2. Actual or compensatory damages. 3. Moral damages. 4. Exemplary damages. And 5. Temporary damages. People v. Nelmeda, GR 184500, September 11, 2012. Prevailing jurisprudence pegs the amount of civil indemnity and moral damages awarded to the heirs of the victim of parricide at $75,000 each. People v. Tibon, 636 Phil 521, 2010 case. The temporary damages awarded by the RTC in the amount of $30,000 should be decreased to $25,000 to also confirm with the latest jurisprudence. It is fitting to additionally award exemplary damages in the sum of 30,000 pesos considering the presence of the qualifying circumstance of relationship. People v. Guting, GR 2054, September 2, 2015. Damages in breach of contract. In contracts and quasi-contracts, the damages for which the obligor who acted in good faith is liable shall be those that are the natural and probable consequences of the breach of the obligation, and which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. 1951 and 1994 bar. So when is moral damages recoverable? In an action for breach of contract, moral damages may be recovered only when a. Death of a passenger results, or b. The carrier was guilty of fraud and bad faith even if death does not result, and that neither of these circumstances were present. In the case at bar, the CA correctly held that since no moral damages was awarded, then there is no basis to grant exemplary damages and attorney's fees to petitioner. To stress, this case is one for breach of contract of carriage, culpa contractual, where it is necessary to show the existence of the contract between the parties and the failure of the common carrier to transport its passengers safely to his or her destination. An action for breach of contract differs from quasi-delicts, also referred as culpa Achilleana or culpa extracontractual, as the latter emanate from the negligence of the tortfeasor. Calalas v. Court of Appeals, 388 Phil 146, including such instance where a person is injured in a vehicular accident by a party other than the carrier where he is a passenger. The principle that in an action for breach of contract of carriage, moral damages may be awarded only in case of 1. An accident results in the death of a passenger, or 2. The carrier is guilty of fraud or bad faith, is pursuant to Article 1764 in relation to Article 2206, number 3 of the Civil Code, and Article 2220 thereof. Darines et al. Versus Quinones et al. GR 206468, August 2, 2017. If there is fraud, bad faith, malice, or wanton attitude, the obligor shall be responsible for all damages that may be reasonably attributed to the non-performance of the obligation, whether the damage is foreseeable or unforeseeable. What are the interests that are included in culpa contractual? In culpa contractual, the mere proof of the existence of the contract and the failure of its compliance justify, prima facie, a corresponding right of relief. The interests that are sought to be protected include: 1. Expectation interest. This is the interest in having the benefit of his bargain by being put in as good a position as he would have been had the contract been performed. Number 2, reliance interest. And this is the interest in being reimbursed for loss caused by reliance on the contract by being put in as good a position as he would have been had the contract not been made. Restitution interest. Interest in having restored to him any benefit that he has conferred on the other party. Damage to property. Under damage to property, damage to or loss of personal property, the plaintiff is entitled to their value at the time of destruction. Normally, the award is the sum of money which plaintiff would have to pay in the market for identical or essentially similar good, plus, in proper cases, damages for the loss of use during the period before replacement. In case of profit-earning chattels, what has to be assessed is the value of the chattel to its owner as a going concern at the time and place of the loss. How about damage to or loss of real property? The measure of damage for a permanent injury is ordinarily the difference between the reasonable market value of the property immediately before and after the injury. Total loss. In case of total loss, the value of the real property at the time and place of the loss must also be assessed, and such assessed value is the measure of the damage due to the plaintiff. Deprivation of possession. Where the plaintiff was merely deprived of his possession, such plaintiff is entitled to the value of use of the premises. Personal injury. The plaintiff is entitled to the amount of medical expenses as well as other reasonable expenses that he incurred to treat his or her relative's injuries. In proper cases, the award of damages may likewise include the amount spent for the plastic surgery of the plaintiff or any procedure to restore the part of the body that was affected. How about future medical expenses or life care cost? Courts may also award monthly payments to the person who was injured to answer for his future medical expenses. If the victim did not die, but he or she will require medical attendance for the rest of his or her life, it is proper to award life care cost because the tortfeasor is liable for all damages which are the natural and probable consequences of the act or omission complained of. Moral damages and civil indemnity need not be pleaded in a homicide case. Moral damages and civil indemnity are always granted in homicide, it being assumed by the law that the loss of human life absolutely brings moral and spiritual losses as well as a definite loss. Moral damages and civil indemnity require neither pleading nor evidence simply because death through crime always occasions moral sufferings on the part of the victim's ears. People versus Oceanas, GR 182548, September 30, 2008. People versus Buduhan, GR 178196, August 6, 2008. People versus Berondo, GR 177827, March 30, 2009. Violent death invariably and necessarily brings about emotional pain and anguish on the part of the victim's family. It is inherently human to suffer sorrow, torment, pain, and anger when a loved one becomes the victim of a violent or brutal killing. Such violent death or brutal killing not only steals from the family of the deceased his precious life, deprives them forever of his love, affection, and support, but often leaves them with the knowing feeling that an injustice has been done to them. The civil indemnity and moral damages are fixed at $75,000 each because homicide was a gross crime. Ladinas versus People et al. GR 167333, January 11, 2016. What is the formula in computing the award for loss of earning capacity? Net earning capacity equals life expectancy times gross annual income less necessary living expenses. Life expectancy. It is the life expectancy of the deceased or victim that is the element of the formula for computing loss of earning capacity, and not the life expectancy of the heirs. The multiplier that corresponds to the life expectancy of the victim may be reduced depending on the circumstances like medical history, dangerous work of the victim. Under net earnings, sufficient evidence, particularly documentary evidence, should be presented by the plaintiff to establish the net earnings of the deceased. Number 1. By way of exception, the court awarded damages for loss of earning capacity even in the absence of documentary evidence in the following cases. The award of temporary damages for loss of earning capacity in lieu of documentary evidence. 2. Cases where the victim was earning less than minimum wage. And 3. Non-working victims. And 4. When testimonial evidence sufficiently establishes the loss, as in the case when the testimonies of the corporate officers of the employer may also suffice, and when the testimony of the widow of the victim was held acceptable because a reasonable estimate of the income can be made on the basis of such testimonies. How about living expenses? The amount of the living expenses must also be established to determine the net earnings. However, the amount thereof is fixed at 50% of the gross income in the absence of proof of the amount of living expenses to be deducted from the gross income. How about on loss of earning capacity of non-working victims? The Supreme Court recognized the entitlement of the heirs of the deceased for loss of earning capacity of deceased even if the said deceased was not working at the time of the accident. What is important is that there is proof of loss of earning capacity and not necessarily actual loss of income. Thus, award of damages for loss of earning capacity may be sustained if the minor victim had good academic record, extracurricular activities, and varied interests that will show that the victim would have enjoyed a successful professional career. Damages for loss of earning capacity was also awarded when the victim was a nurse who used to be a contract worker in Saudi Arabia, but who is temporarily not working or earning a salary due to pregnancy. Loss of profits. The right to recover lost profit is now expressly recognized under the new Civil Code. This may take the form of commissions that were lost by reason of the acts or omissions of the defendant. This may also take the form of income that was stipulated in the contract that was terminated in a wanton and fraudulent manner. How about attorney's fees? The damage contemplated by such article is an amount that is due to the plaintiff and not to his counsel. Attorney's fees are in the concept of actual or compensatory damages allowed under the circumstances enumerated in Article 2208. Consequently, the amount agreed upon by the plaintiff and his counsel does not control the amount of attorney's fees that should be awarded. What are the cases when attorney's fees can be awarded? Article 2208 enumerates all the cases when the award of reasonable attorney's fees in the concept of damages and expenses of litigation other than judicial costs is justified are as follows. 20. O2 bar. 1. When exemplary damage are awarded. 2. When the defendant's act or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest. 3. In criminal cases of malicious prosecution against the plaintiff. 4. In case of a clearly unfounded civil action or proceeding against the plaintiff. 5. Where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just, and demandable claim. 6. In actions for legal support. 7. In actions for the recovery of wages of household helpers, laborers, and skilled workers. 8. In actions for indemnity under workmen's compensation and employer's liability laws. 9. In a separate civil action to recover civil liability arising from a crime. 10. When at least double judicial costs are awarded. 11. In any other case where the court deems it just and equitable that attorney's fees and expenses of litigation should be recovered. Example: Ortilio contracts Fabricado Incorporated to supply and install tile materials in a building he is donating to his province. Ortilio pays 50% of the contract price as per agreement. It is also agreed that the balance would be payable periodically after every 10% performance until completed. After performing about 93% of the contract, for which it has been paid an additional 40% as per agreement, Fabricado Incorporated did not complete the project due to its sudden cessation of operations. Instead, Fabricado Incorporated demands payment of the last 10% of the contract despite its non-completion of the project. Ortilio refuses to pay, invoking the stipulation that payment of the last amount of 10% shall be upon completion. Fabricado Incorporated brings suit for the entire 10% plus damages. Ortilio counters with claims for moral damages for Fabricado Incorporated's unfounded suit, which has damaged his reputation as a philanthropist and respected businessman in his community, and B. attorney's fees. Does Ortilio have a legal basis for his claim for moral damages? How about his claim for attorney's fees, having hired a lawyer to defend him? Answer to letter A, no. Ortilio has not legal basis. It is well settled that moral damages cannot be assessed against the plaintiff by the mere fact that he filed a case against the defendant, or even if the suit is unfounded, so long as the same was done in good faith. Bad faith on the part of the plaintiff should be established. Good faith is presumed. In addition, the facts of the case does not indicate that the circumstances are covered by Article 2219 of the new Civil Code. It is required for the award of moral damages that the case falls within any of the cases enumerated in Article 2219. Answer to letter B. Ortilio is entitled to attorney's fees. Article 2208 of the new Civil Code provides that attorney's fees can be awarded when there is a clearly unfounded suit against the plaintiff and when it is just and equitable under the circumstances. Paragraph 4 and 11, Article 228 of the new Civil Code. Hence, the award of attorney's fees is proper because Fabricado filed a clearly unfounded civil action. How about interest? Interest may be monetary interest, which is interest as income, or civil fruits, or compensatory interest, which is interest as damages or penalty. The leading case of Eastern Shipping Lines Incorporated versus Court of Appeals gave the following guidelines for the application of the proper interest rates, 2002 and 2004 bar questions. 1. When an obligation, regardless of its source, that is, law, contracts, quasi-contracts, delicts, or quasi-delicts, is breached, the contravenor can be held liable for damages. The provisions under Title 18 on damages of the Civil Code govern in determining the measure of recoverable damages. With regard particularly to an award of interest in the concept of actual and compensatory damages, the rate of interest as well as the accrual thereof is imposed as follows. 1. When the obligation is breached and it consists in the payment of a sum of money, that is, a loan or forbearance of money, the interest due should be that which may have been stipulated in writing. Furthermore, the interest due shall itself earn legal interest from the time it is judicially demanded. In the absence of stipulation, the rate of interest shall be 6% per annum, to be computed from default, that is, from judicial or extrajudicial demand, under and subject to the provisions of Article 1169 of the Civil Code. 2. When an obligation not constituting a loan or forbearance of money is breached, an interest on the amount of damages awarded may be imposed at the discretion of the court at the rate of 6% per annum. No interest, however, shall be adjudged on unliquidated claims or damages except when or until the demand can be established with reasonable certainty. Accordingly, where the demand is established with reasonable certainty, the interest shall begin to run from the time the claim is made, judicially or extrajudicially, Article 1169 Civil Code. But when such certainty cannot be so reasonably established at the time the demand is made, the interest shall begin to run only from the date the judgment of the court is made, at which time the quantification of damages may be deemed to have been reasonably ascertained. The actual base for the computation of legal interest shall in any case be the amount finally adjudged. 3. When the judgment of the court awarding a sum of money becomes final and executory, the rate of legal interest, whether the case falls under paragraph 1 or paragraph 2 above, shall be 6% per annum from such finality until its satisfaction, this interim period being deemed to be by then an equivalent to a forbearance of credit. What is mitigation of liability? The liability of the defendant may be reduced in the following cases. When the doctrine of avoidable consequences applies. B. In crimes, the damages to be adjudicated may be respectively increased or lessened according to their aggravating or mitigating circumstances. C. In quasi-delicts, the contributory negligence of the plaintiff shall reduce the damages that he may recover. D. In contracts, quasi-contracts, and quasi-delicts, the court may equitably mitigate the damages under circumstances in the following instances: that the plaintiff himself has contravened the terms of the contract, that the plaintiff has derived some benefit as a result of the contract. In cases where exemplary damages are to be awarded, that the defendant acted upon the advice of counsel, that the loss would have resulted in any event, that since the filing of the action, the defendant has done his best to lessen the plaintiff's loss or injury. So what is the doctrine of avoidable consequences? Article 2203 of the new Civil Code provides that the party suffering loss or injury must exercise the diligence of a good father of a family to minimize the damages resulting from the act or omission in question. And what is the rationale? The principle is that a party cannot recover damages flowing from consequences which the party could reasonably have avoided. It has a reasonable corollary. That is, a person who reasonably attempts to minimize his damages can recover the expenses that he incurred. What is the difference from contributory negligence? Although the result is the same, it should be differentiated from contributory negligence, because in the latter, the plaintiff's act or omission occurs before or at the time of the act or omission of the defendant. The acts of the plaintiff under the doctrine of avoidable consequences occur after the act or omission of the defendant. Cases when moral damages may be awarded. Articles 2219 and 2220 of the Civil Code enumerates the cases when moral damages may be awarded by the courts. 1992, 2002, and 2006 bar questions. 1. A criminal offense resulting in physical injuries. 2. Quasi-delicts causing physical injuries. 3. Seduction, abduction, rape, or other lascivious acts. 4. Adultery or concubinage. 5. Illegal or arbitrary detention or arrest. 6. Illegal search. 7. Libel, slander, or any other form of defamation. 8. Malicious prosecution. 9. Acts mentioned in Article 309, anyone who shows disrespect to the dead or wrongfully interfering with a funeral shall be liable to the family of the deceased for damages, material and moral. 10. Acts and actions referred to in Articles 21, 26, 27, 28, 29, 30, 32, 34, and 35. 11. Willful injury to property may be a legal ground for awarding moral damages if the court should find that, under the circumstances, such damages are justly due. 12. Breaches of contract where the defendant acted fraudulently or in bad faith. Fixed moral damages are provided for by the Supreme Court in criminal cases. The rules and the specific amounts depending on the crime and other circumstances are summarized in the en banc cases of People v. Hugueta. Requisites for moral damages to be awarded. There must be an injury, whether physical, mental, or psychological, sustained by the claimant. 2. There must be culpable act or omission factually established. 3. The wrongful act or omission of the defendant is the proximate cause of the injury sustained by the claimant. And 4. The award of damages is predicated on any of the cases stated in Article 2219. Who may recover moral damages? The victim. 2. The parents of the female seduced, abducted, raped, or abused, referred to in number 3 above. Number 3. The spouse, descendants, ascendants, and brothers and sisters may bring the action mentioned in number 9 above in the order named. The relatives mentioned in Article 2209 number 3 are limited to the relatives named therein, inclusion, unius as exclusio alterius. Hence, brothers and sisters cannot recover moral damages for the death of their sibling. In the case of corporations and other artificial beings are not entitled to recover moral damages. Exception: libel. A corporation can be an offended party in a defamation case, and it can recover moral damages under Article 2219, number 7 of the Civil Code. So what are the factors in determining the amount? The determination of what would be a fair amount of moral damages must be governed by the own peculiar circumstances of the case. Factors specified by law and established by jurisprudence that could affect the amount to be recovered include: 1. The sentimental value of property, real or personal damages. 2. Extent of humiliation. 3. Extent of pain and suffering. 4. Official, political, social, and financial standing of the offended party in the business and financial position of the offender affects the amount of damages. And 5. Age of the victim. What is a nominal damage? Nominal damages are adjudicated in order that a right of the plaintiff, which has been violated or invaded by the defendant, may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. The nature is: nominal damages, by their nature, are small sums fixed by the court without regard to the extent of the harm done to the injured party. In truth, nominal damages are damages in name only and not in fact, and are allowed, not as an equivalent of wrong inflicted, but simply in recognition of the existence of a technical injury. When is it proper? The award of nominal damages is proper in an action arising from any of the sources of obligation under Article 1157. When 1. The plaintiff suffered injury. 2. The injury arises because the legal right of the plaintiff is violated. And 3. There is no actual or other damages established or other none appears on injury. Can it coexist with actual damages? Nominal damages cannot coexist with actual or compensatory damages. The purpose of nominal damages is to vindicate or recognize a right that has been violated in order to preclude further contest thereof, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. An award of actual damages is a vindication of a right. An award of actual damages in itself recognition that plaintiff's right was violated. Hence, the award of nominal damages is unnecessary and improper. Nominal damages are recoverable where a legal right is technically violated and must be vindicated against an invasion that has produced no actual present loss of any kind. Its award is thus not for the purpose of indemnification for a loss, but for the recognition and vindication of a right. In the present case, Gonzalez had the right to be informed of the accrued interest and most especially for the suspension of his COLA. For failure to do so, the bank is liable to pay nominal damages. Moreover, the failure to give prior notice when required constitutes a breach of contract, and is a clear violation of Article 21 of the Code, which entitles the client to an award for moral damages. Even in the absence of malice or bad faith, a depositor still has the right to recover reasonable moral damages. If the depositor suffered mental anguish, serious anxiety, embarrassment, and humiliation. Eusebio Gonzalez versus PCIB et al. TR 180257, February 23, 2011. Temperate or moderate damages. Temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when the court finds that some pecuniary loss has been suffered, but its amount cannot, from the nature of the case, be provided with certainty. The amount of temperate damages must be reasonable under the circumstances. Examples of cases when award is proper. These are cases when the right of plaintiff is violated but only temperate damages are awarded instead of actual damages. 1. When there is injury to one's commercial credit or to the goodwill of a business firm, or even if there is pecuniary injury to the business, but the extent cannot be shown with certainty in terms of money. 2. Temperate damages may be awarded for future medical expenses, where the injury is chronic and continuing and there is proof of the need for such expenses. 3. Temperate damages may be awarded in lieu of actual damages for loss of earning capacity, where earning capacity is plainly established but no evidence was presented to support the allegation of the injured party. In murder cases, the Supreme Court pegged the amount of temperate damages at $25,000 if actual damages, including funeral expenses, were not established. In the absence of competent proof on the amount of actual damages suffered, a party is entitled to receive temperate damages. Manila Electric Company, Meralco versus Castillo. Citing Duenas versus Guse, Africa, GR 165679, October 5, 2009. Article 2224 of the New Civil Code provides that temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when the court finds that some pecuniary loss has been suffered, but its amount cannot, from the nature of the case, be proved with certainty. The amount thereof is usually left to the sound discretion of the courts, but the same should be reasonable, bearing in mind that temperate damages should be more than nominal but less than compensatory. Considering the concomitant circumstances prevailing in this case, temperate damages in the amount of $350,000 is deemed equitable. International Container Terminal Services versus Chua, GR 195031, March 26, 2014. Liquidated damages. Liquidated damages are those agreed upon by the parties to a contract to be paid in case of breach thereof. The obligor is bound to pay the stipulated amount without need for proof on the existence and on the measure of damages caused by the breach. Reduction of liquidated damages. Ordinarily, the court cannot change the amount of liquidated damages agreed upon by the parties. One exception is Article 2227, where the new Civil Code provides that liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or unconscionable. Not available if breach is not contemplated. Of the new Civil Code provides that when the breach of the contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measure of damages and not the stipulation. How about exemplary or corrective damages? Exemplary damages are imposed as a deterrent against or as a negative incentive to curb socially deleterious actions. Exemplary or corrective damages are imposed by way of example or correction for the public good, in addition to the moral, temporary, liquidated, or compensatory damages. A stipulation whereby exemplary damages are renounced in advance shall be null and void. The requisites for the award of exemplary damages are as follows. 1. Exemplary damages may be imposed by way of example, in addition to compensatory damages, and only after the claimant's right to them has been established. 2. They cannot be recovered as a matter of right, their determination depending upon the amount of compensatory damages that may be awarded to the claimant. And 3. The act must be accompanied by bad faith or done in wanton, fraudulent, oppressive, or malevolent manner. 4. The plaintiff must show that he is entitled to moral, temporary, or compensatory damages before the court may consider the question of whether or not exemplary damages should be awarded. When does the court grant this? And before I continue, if you're not yet subscribed to me, please go ahead and hit that subscribe button. It's free. And be notified with my next audios. Thank you. Before the court may consider the question of granting exemplary in addition to the liquidated damages, the plaintiff must show that he would be entitled to moral, temporary, or compensatory damages were it not for the stipulation for liquidated damages. Cases when available. In criminal offenses, exemplary damages as a part of the civil liability may be imposed when the crime was committed with one or more aggravating circumstances. Such damages are separate and distinct from fines and shall be paid to the offended party. Fixed exemplary damages are provided for by the Supreme Court in criminal cases. The rules and the specific amounts, depending on the crime and other circumstances, are summarized in the en banc case of People v. Hugueta. In quasi-delicts, exemplary damages may be granted if the defendant acted with gross negligence. In contracts and quasi-contracts, the court may award exemplary damages if the defendant acted in a wanton, fraudulent, reckless, oppressive, or malevolent manner. So, will you be now able to answer this question? 1. Rosa was leasing an apartment in Baguio City. Due to the rent control law, her landlord could not increase the rental as much as he wanted to, nor terminate her lease as long as she was paying her rent. In order to force her to leave the premises, the landlord stopped making repairs on the apartment and caused the water and electricity services to be disconnected. The difficulty of living without electricity and running water resulted in Rosa's suffering a nervous breakdown. She sued the landlord for actual and moral damages. Will the action prosper? Explain.